Here we are showing you the process to become copyrighted. And basically, in your case, I know you have a number of things that you have created as far as sound is concerned. Have you done any copywriting kind of work?
Kind of, yes.
Okay, tell me what you've done.
In the old days, I registered songs and scores with my lawyers in Gibraltar.
Okay.
But basically, it's just proof that I created whatever I created
Yes.
at a certain date and time.
And that really is all that needs to be done. First off, the one thing that you need to realize, when you write a paper in a class, that's yours. That's yours. Nobody else can take that. Secondly, although you have not applied for a copyright, you still have that copyright available to you. If you want to make it legal, it really isn't that difficult. What you do is you take your item, and I'll use my book as an example. I sent a copy of my book to the U.S. Congressional Records, and they issued a copyright. I had to pay, I think, $30 in order to do that. That's all you need to do. If you have photographs, by the way, photographs, your own photographs, those are yours. And you have the license, or you have the right to do whatever you want to do with those. So if you're posting a picture on Facebook, you very well might want, and if it's a specific picture that you do not want people to copy and to use, you very well might want to put copyright in your name and the year. And that is a start. That is a start. So once again, pictures, drawings, those kinds of things, if you send those and apply for a copyright, you will be granted that copyright. And the website here shows you www.copyright.gov, and that shows you and talks to you how to do that, where to send it, etc., etc., etc. And you might want to make note of that, particularly if you...
Hello, this is Jeff Loman, and today I'm going to talk to you about how to effectively make a copyright for your photos. Alright, so biggest thing is that we need to know about copyright is that as soon as you take the photo, that is your possession. You own that photo. That photo is copyrighted. Now, there are a few exceptions to this, and they are very contractually based. One is for work for hire. Now, when you work for hire, that is a client of yours has paid you to shoot photos for them. And specifically stipulated within the contract, it must say that those photos are the client's possession. So you take some photos, and it's on your memory card or on your roll of film, and in the contract that you sign, says that you must hand that over, and that they are their property. You don't have the copyright for those. Those belong to the client. And so you have to make sure that that's stipulated, or else they still belong to you. And you might, if this goes to court or anything, you might want to show the contract that you signed that it has no information or no parts in it to say that the photos belong to the client. Now, another thing is talking about a registered copyright. Like I said, copyright, you own the photo. Now, the safest way in the United States to actually affirm that you own the photo is by a registered copyright. And what that is that you actually send the photo on digital media, probably like a CD or a DVD, photo or photos, to the Library of Congress. And that is going to, and they're going to send you a confirmation that they have received it if you send it via priority mail, that they received it, and they're going to affirm that you own the photo, and that's in a really safe place that's going to be held up in court, that you have to pay $30 for it, but like I said, it is the safest way, and you have a registered copyright for that material, and you're...
So, that's what you want to do as far as photos are concerned, or other work such as that. Tonight what we're going to be doing is we're going to be talking about some court cases, United States court cases, that address some of the issues that we are talking about, and we're going to be looking at how those might affect you as an individual. In this particular court case, Britannica brought suit against Crooks, and basically Britannica had digital videos, if you will, and a school educational service center was making copies of those and sending them out. Clearly a copyright violation. Clearly a copyright violation. And Britannica won the suit. I can't remember exactly how much they won, but it was determined how many times they violated, and based on the times violated, there was a charge based on that. Fortunately, no individual teachers were caught up in that lawsuit. And that's the one thing that we want to kind of mention to you, is that, of course, you're fortunate, we've been fortunate at this particular point, that there has not been suits won that have gone right at individuals. I don't have this one up here, but colleges get involved, particularly in songs. And if songs are loaded on a server by students, the many companies have gone after colleges and won. So therefore, that is a real concern. Of course, we realize that songs these days are easy to get a hold of and easy to reproduce. And so you have to understand that the artists spend lots of their time, energy, and effort, and that's what the charge is for. And so therefore, obviously, the courts have said that if those are copyrighted, they ought to be reimbursed for any violations that take place. So, we've evolved from copyright. We are in a reproducing world. And in order to kind of accommodate this, Creative Commons came on the scene. And Creative Commons is an organization, and they have different licenses that one may get in order to allow others easy access to their work. And here you can see attribution. In that particular license, what it means is that if you use this work and it has a Creative Commons license attached to it, then all you have to do is give that individual who created it their due rights. Just state who they are. That's all you need to do. You can reproduce, you can do any of those kinds of things. No derivative works. Others can copy and distribute and display and perform those copies. Share alike. You share it with the exact same license that you have. So, and non-commercial. I mentioned that in my book, I really looked for Creative Commons kinds of work. Some of those were not identified as Creative Commons. So I just contacted the individual and asked them if I might be able to reproduce it. I explained to them, in one particular instance, they did have non-commercial. I explained to them that this book was going to be sold, although wasn't going to be probably lots of books sold. There were going to be fewer books sold, and they granted me permission to use that. So therefore, with Creative Commons, we have the opportunity to make adjustments, change color, change various kinds of things with the work, which is really very, very handy, as you might guess. And in order to get a license, you just go on this site, you load what it is you have, and you let it be known what license you are placing on this, and it's completed. I use for school law, I created my own rubric for taking a look at threaded discussions. And I decided that I was going to kind of do two things. First of all, I'm trying to educate students about Creative Commons, but I also wanted to allow people to use it if they saw it and they wanted to reproduce it. And so therefore, I give them license to do that under attribution. Okay.